All right, good afternoon. I will now begin the Fair Housing Overview webinar. Again, thank you all for joining this afternoon from wherever you are, assuming it's afternoon depending on your time zone. In any case, my name is Seth Embry. I'll be the presenter today for the Fair Housing Overview webinar. Just a few housekeeping things. You do or you should have the ability to ask questions with the GoToWebinar tool. So feel free to do that at any time. There's also my email there. If after the webinar you have some additional questions, feel free to follow up that way. Again, my name is Seth Embry, and welcome to today's webinar. I'm going to go ahead and start with an introduction to myself and Quadell. If you're not familiar, Quadell is a management and consulting firm. We're headquartered in DC, as it says there, recognized for our expertise in many affordable housing programs, including public housing, housing choice voucher program, mod rehab, HUD, subsidized multifamily programs, low-income housing taxpayer programs, and many others. We've been providing training and technical assistance, consulting, and program management services since 1978 to a variety of public housing authorities, state housing agencies, and also to private sector clients, owners, managers of assisted housing, and assisted private housing developers. I'm a senior associate with Quadell. I've been with the firm for over 3 years now and had in total about 10 years experience in housing. I worked in multiple settings and with multiple populations, from recovery housing to solutions for chronically homeless populations, permanent supportive housing, housing mobility programs. I've worked with HCV departments, public housing, maintenance, you name it. I have a lot of experience, including what we're covering today, which is fair housing. So I'll just show you our agenda today. We're going to start with a little bit of a background to fair housing. This is an overview, so I want to give everyone a good foundation and background for understanding fair housing, also the Fair Housing Act and things that are really going to pertain to what you do. We'll talk about what's prohibited in terms of actions and what's required. We'll talk about recent developments and future opportunities for you to learn more, because as I said, this is an overview. So we'll be thinking about concepts, history, laws, again, prohibited and required activities. I'm going to cover some detailed areas like reasonable accommodations and modifications. And this little guy here is my my symbol for shameless plug, so I'm going to give you one now, and you'll get more later. But there will be a part 2 to this webinar in May, on May 17th, as we have there, where I'll go into more detail on really specific areas of fair housing, including disability, including criminal records, including some other areas. Again, that'll be May 2nd, and you'll need to register for that as well. We'll also do a certification course in early June in Philadelphia, an in-person course, and there will be details later. We'll send those out to your email if you're interested, and you can register for that. But I want to center today's discussion on the federal rules, and know that there are going to be rules that vary by your state and by your locality that you need to be aware of. But in any case, let's get right into it, into the discussion. So fair housing, and I'm going to start here with this image I have of this this fence, because housing discrimination is like a fence. And yeah, this picture will show you fences are nice for landscaping, keeping kids in their yard, but when used to keep people out of housing and out of communities. These kinds of offenses, this discrimination, is really an eyesore, a blemish to our entire society. So at the time of the passage of the Fair Housing Act, which we'll talk about in a little bit, discriminatory practices such as steering and racially restrictive covenants were in wide use. Fair housing laws seek to take down these fences by protecting vulnerable populations from unfavorable treatment for no other reason than who they are. And prior to these laws, discrimination was rampant in housing, particularly on a person-to-person basis. So even though in many areas of the country there might not have been segregation by law, de jure segregation, there were practices that had substantially similar effects, which we consider de facto segregation. So out of those conditions was born the Fair Housing Act. This is the bedrock of federal efforts to end discrimination in housing, and it's even a blueprint for state and local legislation and efforts to the same end. It's not the first fair housing law in the nation. It was preceded by efforts most notably in California, but because it's a federal law, it extended protections all across the country. It was signed into law, as you see there, in 1968, part of the final package of Civil Rights Act. In fact, it's known as Title VIII of the Civil Rights Act of 1968. And one piece of history I can share here is that before he passed, one of Dr. Martin Luther King's foci in the last years of his life was fair housing, particularly in northern cities such as Chicago, where he led a fair housing movement between 1965 and 1967. And this relates to what I was talking about in the last slide, which is de facto segregation. So in Chicago, there wasn't legal segregation, but people acted in that way by preventing people of certain color or national origin or race from moving into communities or from buying properties or getting home loans. And in fact, the idea of fair housing and the Fair Housing Act is really tied closely to Dr. King. And on the date that the Senate was to vote on final passage of the Fair Housing Act, that was actually the same day of the assassination of Dr. King. The House will go on to approve the Fair Housing Act a few days later, and President Johnson would sign it into law. Let's stop here so I can quickly define a few key terms that will guide us throughout the rest of the discussion today. And I have two here, discrimination and protected class. So discrimination is making a decision in favor of or against a person on the basis of the group, class, or category that they belong to. And those groups, classes, or categories, we know those as protected classes when it comes to these kinds of anti-discrimination efforts. And these are groups that have been historically targets of discrimination, again, because of physical innate characteristics. We'll go over it in detail, the protected classes, a little bit later, but I wanted to set kind of the table, so to speak, so that we're all aware of those terms, what they mean pertaining to the Fair Housing Act. So in addition to the Fair Housing Act, there are several other pieces of legislation that provide protections against discrimination in housing. And depending on your role in housing and the type of housing program or building you manage or operate in, various laws will apply to you specifically. Additionally, if you work in a federally funded housing program, there are going to be presidential executive orders that apply to you as well, which I'm not going over now because they're wide-ranging and they're not going to apply to everyone that's listening to that. And I also want to mention that in addition to traditional housing programs such as owners, such as property managers, such as real estate agents, non-traditional housing market participants are also subject to anti-discrimination laws. And the third bullet point there, Title IX of the Education Amendments Act of 1972, is a great example because that applies to schools to the extent that they provide housing to students. In addition to those federal laws and presidential executive orders, states often and localities often enact additional protections to ensure fair housing that meet the needs of the local community. So in every state, there's probably going to be a Fair Housing Commission or Human Rights Commission or agency that's responsible for investigating claims of discrimination and enforcing those claims, enforcing the state laws rather. So you should become familiar with those on the state level, but also local fair housing groups that do investigations, that do enforcement, but also there will be probably nonprofit groups that provide education, mediation, and other services in your community. So back to the Fair Housing Act. Let's think about fair housing in terms of what and who. The Fair Housing Act defines what is prohibited and who is subject to following anti-discrimination laws, in addition to who those protections extend to. We'll start by talking about the what. These actions here that I have bulleted are prohibited against members of protected classes, and these come straight from the Fair Housing Act. These prohibitions deal with preventing access to housing. So these are the offenses that I talked about. When you refuse to sell or rent to a member of a protected class because of their membership in that class. When you give different terms or conditions in the sale or different privileges. Let's think about a building that has amenities, maybe a pool or a laundry room or something else, and only certain people can access those amenities and certain people can't, even though they're all legal residents of that building. Third bullet point there, advertise any preference or limitation with respect to the sale or rental of a dwelling. And so this, commonly you'll hear things nowadays, great examples of these, if you advertise a property or an apartment for rent and you describe it maybe in a community with, a quiet community with very few children, that could be discriminatory. Or if you describe it as a great Jewish community, that could also be discriminatory, because even though you don't say we really want Jewish people to live here or we really want families without children to live here, it's going towards the same end of expressing a preference for the type of person who you might want to live there. So those are really important today, as outright and blatant discrimination has gotten more and more rare. It's still an issue, but it's not the issue it was when this was passed in 1968. But the advertising of preferences are where people can get tripped up because you think you're talking about amenities, where it could come across, if I, for instance, read something that says great for, it's a community with very few children, and if I've got children, I might feel that my children wouldn't be welcome there, and so that's a barrier that's been placed there, even unintentionally. So it's also illegal to mislead an individual about the availability of housing. And what we hear about today, fair housing agencies do testing, and they test based on maybe national origin, maybe with people of different, of an accent of an Asian individual or a Hispanic individual, to see if they'll be treated the same way over the phone or in person about whether housing is or is not available. Now, that bullet point there was really common when this act was passed, and this was known as blockbusting. And so people might be induced to sell property because they hear that black families are moving into the community, and you better sell now before property values go down or something like that. And so that was also made illegal by the Fair Housing Act. There are also a group of protections specifically for individuals with disabilities, and these ensure that those individuals have the ability to live in integrated communities, and that goes with reasonable accommodations, reasonable modifications, and the modifications of existing buildings, dwellings, and construction of new multifamily buildings. Those have to be accessible to individuals with handicaps and disabilities. We'll talk more about reasonable accommodations and modifications later, but in case you're wondering, reasonable modifications, which are changes to units, changes to that permit people to use them, those, and I'll repeat this later, but those have to be permitted, but they have to be permitted at the tenant's expense. Landlords may condition approval of these modifications on future restoration by the tenant. And again, like I said, we'll talk more about those later so you can really get a good idea about those. And this, again, these are mandated by the Fair Housing Act. So you have to permit reasonable modifications. You have to make reasonable accommodations. So those last two slides, those again were lifted directly from the text of the Fair Housing Act. Now I have a link at the end of this to the Fair Housing Act, to a website where it's contained, so you can go and read it if you choose. But beyond the Fair Housing Act, to ensure that the letter and the spirit of the law is realized, regulations have been enacted to address issues as they arise. And those are almost always coming from the Department of Housing and Urban Development, who is charged with enforcing the Fair Housing Act. So some of those are here. So unreasonable occupancy restrictions, demanding sexual favors or creating a sexually hostile environment, failure to stop one tenant from harassing another tenant, suggesting someone will be unsafe in certain neighborhoods. These are kinds of things that aren't in the text of the Fair Housing Act, but again have been ruled illegal by HUD, which again enforces the Fair Housing Act. I'd like to give a note here about that first bullet, which is occupancy restrictions. So those are common, right? States and towns and what have you, for safety reasons, will have policies that restrict the number of people to a unit by bedroom size. That's common. And building owners, managers might also have similar policies. And their existence is fine. The problem happens when they're unreasonable. And that's going to depend both on what the local law is, but the local law might be unreasonable. And so it's really going to be on a case-by-case basis. 2 people per bedroom is a common standard. However, it's not a hard and fast rule. So depending on the space and layout of a home, of an apartment, a condo, that number could go up or even down. Also, FYI, infants are typically not included in that count. So what do I mean by that? For instance, a 1-bedroom apartment that's suitable for 2 adults is probably suitable for 2 adults and a baby. But again, this is going to depend on the actual space and the layout, but it's just important to know as you think about the way your program or building runs, or if you're here and you work for a city agency, as you think about maybe looking at your own occupancy standards to determine if they're reasonable or not reasonable. So the Fair Housing Act has a couple of other sections. This one here, the Discrimination and Brokerage Services Clause, this deals with discriminating against people seeking to engage in the business end of selling or buying real estate or renting. So you can't deny access to someone who wants to have access to the local MLS, a brokerage organization, or any other organization in the business of selling or renting dwellings. The last part of the Fair Housing Act deals with harassment. And what that means is that you cannot interfere with or harass someone who is seeking to enjoy their rights to fair housing or helping others enjoy those rights. It's also unlawful for any person or entity whose business includes engaging in residential real estate related transactions to discriminate against another person in making available such a transaction or in the terms of that transaction based on one of the protected classes, which we're going to go over in a second. And so what this means is that if we're talking about loans, for instance, you can't give one set of terms to one group of people and another set of terms to a different group of people based only on their membership in a protected class. That's going to be stuff like race or religion, for instance. So with the rules, the prohibitions that I talked about before, there are exceptions. And here I have the first line of the Fair Housing Act. And I thought this fancy script would be appropriate to kind of signify that this was part of the legislation. Seems very official, I think. So this reads, the first line of the Fair Housing Act reads, it is the policy of the United States to provide within constitutional limitations for fair housing throughout the United States. And that's important, and that's illustrated in the exceptions, the exemptions I'm going to go over. The reason for those exceptions is that legislators wanted to respect the rights of private individuals to have whatever thoughts that they want. Those are, First Amendment rights that we hear so much about. And act in whatever way they want, conduct business how they want, although the same legislators wanted to ensure that any adverse impact to the general public was as narrow as possible. So, what are those exemptions or exceptions? Religious organizations, societies, and associations can limit the sale, rental, or occupancy of residential dwellings to persons of the same religion, unless membership in that religion is restricted on account of race, color, or national origin. So, as long as you don't discriminate in your religious organization or association against certain protected classes, you can restrict housing that you own to members of your own religion. Private clubs can restrict rental and occupancy of non-commercial property that it owns to its members. Again, private clubs. So these are clubs not open to the general public. The last bullet there, where it says owner occupants of buildings with 4 or fewer units, where, and to be clear, where the owner resides in one of those units, that's known as the Miss Murphy's exception. And so what that says, if I personally own a building that has 3 units in it, and I live in one of those units, the fair housing prohibitions against discrimination don't apply in the rental of those units. However, what I cannot do is advertise any limitations or preferences. And so while the law says I can deny people based on religion or race, and that for those other 2 units in that 3-unit building where I live, I cannot write an advertisement that says unit available in 3-unit building for family, no children allowed, or only a certain, no Christians allowed. I couldn't do that. I do want to note here that these exceptions apply to the federal law. Okay, so that means that a state or local town or city can have different laws. For example, in Pennsylvania, this exception here, Ms. Murphy's exception, where on the federal level it's for 4 units. In Pennsylvania, it's buildings with no more than 2 units. So it's important to understand the federal law governs the entire nation, but you'll have specific regulations that you need to pay attention to based on where you live. Now, let's move on to the WHO, which are the protected classes. Here I have for you the 7 protected classes under the Federal Fair Housing Act. When the act was passed in 1968, there were 4: race, color, religion, and national origin. Later amendments added sex in 1974 and disability and familial status in 1988. Familial status refers to families with children under 18, pregnant women, or individuals in the process of obtaining legal custody of individuals under 18. So what that means is that if we think back on the slide where I had the prohibited activities listed, one of those was refusal to rent housing. So when it comes to familial status, I can't say I refuse to rent this unit or this apartment or home to families with children under 18, but I will rent it to families with children over 18. I can't say I refuse to make a loan to Hispanic individuals or individuals from Germany, national origin. And I can't advertise preferences for males or females in a multifamily building or for individuals with or without disabilities. So something I do want to talk about with those last 2 additions, disability and familial status. For the exception for the protections for people of familial status, they do not apply to housing intended for the elderly, for older persons. And what does that look like? State or federal programs for the elderly, housing that's intended for and solely occupied for individuals 62 and older, or housing intended for and operated for occupancy by persons 55 or older. And that last one, 55 or older, that has certain characteristics which the building would need to follow in terms of the percentage of people that are that age or older, in terms of the policies that indicate it's intended for individuals 55 or older. And so if you operate a building, own a building, or seek to operate or own a building for older persons, you really need to be up on those restrictions. So for age or disability protections, if I have a building that's designated for the elderly or for disabled, I can deny applicants that don't meet that criteria. I can't ask for details of a disability, but I can require verification of the disability to be provided. And in fact, I should be doing that. Additionally, a landlord can require that the applicant prove that they're able to comply with the terms of the lease. And what does that mean? That means that if an individual has a mobility impairment, for instance, they still have to be able to meet all other requirements of the lease, such as paying their rent on time, such as how to dispose of trash and things of that nature. And we'll talk about the accommodations for those individuals, for disabled individuals, to ensure that housing is accessible for them. If they're not able to do that, they would have to request an accommodation, which would have to be provided for them if it meets certain criteria, which we'll go over. in terms of the protections for national origin, for federally funded rental assistance programs, citizenship and eligible immigration status requirements must be met. And we don't consider that discrimination where, for instance, in the Housing Choice Voucher Program, there are certain requirements for individuals to be citizens or of eligible immigration status. And if they're not, they can be denied for such. Also, in the private market, it's not necessarily illegal to have citizenship requirements, but what is clearly illegal is for you to treat someone who looks like they could be an immigrant differently than someone who does not look like they could be an immigrant or have a name that seems foreign to you or speaks a foreign language. You can't treat them any differently. So if you ask, for instance, for a photo ID or a social security card from applicants, it has to be for all applicants and not only the applicants that you think might not have a social security card because of their immigration status. So that's some information on protected classes. Now what I want to cover is forms of discrimination. So I have given you the definition earlier of discrimination, which was treatment in favor of or against someone because of their membership in a protected class. And we've gone over those protected classes. But let's talk about the forms of discrimination, because this is really important. So here I have intentional discrimination, which is the purposeful discrimination where as an owner or a manager I decide to prevent someone from living somewhere or obtaining a loan if I'm in a loan making business, or if I'm a real estate agent and I'm steering people to certain communities or away from certain communities, and I'm doing that on purpose. That's intentional discrimination. So disparate impact, however, can be unintentional, but it's still illegal. And so you might be wondering what that building is there, or you might recognize it. But that's the home of the United States Supreme Court down in D.C. Why is that here? Well, just a few years ago, something very significant happened in that building concerning fair housing and the disparate impact doctrine specifically. And that was the decision in the Texas Department of Housing and Community Affairs versus the Inclusive Communities Project. And what this was a case in which the Inclusive Communities Project, ICP, sued because of the placement of affordable housing in high poverty communities and a pattern of this placement. And while it's not, the Fair Housing Act doesn't say that you can't put affordable housing in certain communities. What ICP said was that by doing that, it had a discriminatory impact, a disparate impact on people of color, minorities. So it was discriminatory, even not by the way the policy was written. By its practice, it had a negative effect on certain protected classes. This is the disparate impact doctrine. It's a long-used fair housing enforcement tool that's made really great strides in eliminating discrimination throughout the housing industry. So not just in the sale and rental of housing, but also in lending, insurance, and public policy. So even though it was widely used, number one, it wasn't written into law, and so it was widely used and accepted, but it hadn't really gotten the seal of approval from the federal government. And in this case, the Supreme Court essentially gave it the seal of approval to be used as a tool with certain limitations, but it can be used as a tool to eradicate discrimination that's not blatant intentional discrimination. So an act is considered discriminatory if it has the effect of discrimination, even if it's not intended in that way. And so I have two examples here. An apartment complex only counts wages in its determination of an applicant's ability to afford to rent, excluding Social Security benefits, disability payments, and other forms of unearned income. The second example I have here is a mobile home park that charges rent per person. And if you're not familiar with mobile home parks, typically they'll charge occupants a fee to rent a space, and then the occupant will put their mobile home on the space. That happens frequently. And so if I say I'm going to rent the same space for a different price depending on how many people are living there, that can have a disparate impact on families with children. So if I'm an individual and I move there and I pay $500, and if my brother moves there and it's $600 because it's him and two children, that has a discriminatory effect by familial status. Now, with the first example about wages and determinations of an applicant's ability to afford rent, what that means is I'm making a determination that you can or cannot rent here based on your ability to pay. And by not allowing Social Security benefits or disability payments, I'm going to be excluding older individuals and disabled individuals from that property. And so we saw disability as a protected class. And so even though this policy doesn't say individuals with a disability cannot live here, it would have that effect if implemented. So anyone enforcing rules which have a disparate impact is subject to the same penalties under the Fair Housing Act as someone who intentionally discriminates against individuals. And so it's very important, and I'll talk about owner and management policies later and how important they are, but it's important that they're examined to ensure that they won't have a different impact on members of a protected class than members who aren't of a protected class. So I mentioned before reasonable accommodations and modifications. And these are to allow access to disabled individuals to live anywhere they want to, instead of in only certain areas or certain buildings that have the features that they need. So a reasonable accommodation, we'll talk about first, is a change or a modification of policies, practices, or procedures for people with disabilities that is necessary to ensure equal access to the premises or to amenities, services, and programs. What might those look like? Your rental application, offering it in larger print. Allowing a deaf individual to interact with you with the use of a sign language interpreter. Allowing someone to mail forms to your management office or company instead of bringing them physically into the office if they have mobility impairments. And if it's a housing program, in the Housing Choice Voucher Program, a great example is approving a larger voucher size for necessary living aid or large medical equipment. Those are all changes in organizational policy that benefit someone, again, with a disability and allow them to access a program, access the premises just like anyone else. So what's a reasonable modification? These are structural changes made to existing premises so that a disabled person can use the unit, the building, just the same way a non-disabled individual can. Examples: having a flashing light attached to a doorbell for, again, someone who's deaf and can't hear the doorbell. Replacing doorknobs with the type of lever hand hardware that you see here for someone who has a disability that makes it difficult or impossible for them to grab and turn the doorknob, this kind of hardware can be used more easily, or it could also be used with a tool, a cane, or in other instances an animal. An assistance animal can open doors for an individual. So reasonable accommodation and modifications, like I said, they are required. Modifications are required at the tenant's expense, so you're not necessarily required to come out of pocket for these modifications, but they have to be, you have to consider the requests. And so you need to think about when you approve requests and when you deny requests. So the framework you have to operate in is that requests must be granted when a qualified individual with a disability, when they make a request that is necessary and reasonable. Those are two key terms that are important. And something else I want to say about these requests, it doesn't have to come in any particular form. For instance, you cannot mandate that all requests come in writing. You also cannot mandate who they come from. So I could make a request on behalf of my grandmother who lives in your facility. But the request does have to be necessary, and it does have to be reasonable. Necessary, with the term you might hear commonly is nexus. There has to be a connection between what the individual disability is and what the requested accommodation is or modification. So for instance, if I have a mobility impairment, an accommodation that doesn't address that impairment, if it's, for instance, a form in larger print or a sign language interpreter, those wouldn't seem necessary. But if it's lower cabinets or a raised toilet seat, that might be necessary. Reasonable. Reasonable is a little different because although we want to enable access for people with disabilities, we also don't want to make it too hard for people to operate a building or a housing program. So we got to think about what's the cost. Is the change affordable? Will it negatively affect the owner's or manager's ability to serve others, or drastically change the way that they offer services? Or are there other ways to meet the family's needs? So just because someone comes to you with a specific request doesn't mean that that request is the only way to accommodate their disability. And so having a conversation with that individual and presenting alternatives is a good way to meet their needs while not putting too much of a burden on your building, property, or agency. So I want to talk briefly about what to do when a family reports an experience with discrimination to you. The first thing is refer to your company policy. And I talked about this before, a few slides before, about the importance of company policy when I talked about disparate impact and making sure that your policies don't adversely affect certain protected classes or a protected class. So you want to follow your company policy on what to do when discrimination is reported. Okay? What you also want to do is if a family tells you that they've been discriminated, they feel like they've been discriminated against by you or an employee or someone else in your building or company, you want to make sure that they know, hey, go to HUD, report your discrimination complaint. You can do that online. I have a screenshot there of the website. You can do it over the phone. But you want to know, you want people to know that they can report this this incident, so that they don't feel like they can't come back later and say that you prevented them or discouraged them from doing so. Which would be, if you remember harassment, part of that is preventing someone from enjoying their rights, and part of enjoying your rights is filing a complaint and having a judgment in your favor, or having the ability to get a judgment in your favor. So tell the family how to file a complaint. Allow the party to express their concern. So allow them to tell you what the issues are and what happened, and listen and see if there's something that you can work out with them. But what you never want to do is give your opinion about whether discrimination occurred or discourage the complaint. So even if someone comes to you and says, you know what, I feel like I was discriminated against because I was told that I can't use the elevator, and I was told that because I'm a woman. That would be sex discrimination. And you might know that this individual was not told that they couldn't use the elevator because that they're a woman, but because the elevator wasn't working. Even still, it's not your role to say, you know, that wasn't actually discrimination, this is what happened. It's your role to say, you know, I hear you, I'm sorry that happened to you. Maybe can I do something for you to resolve that in your favor? Here's how you can report a claim of discrimination, but never discourage someone from reporting a claim about discrimination. And if you don't have a policy, about what to do when discrimination is reported against you, you want to make sure you have one. In part 2 of our webinar in May, again, shameless plug, in part 2 I will be talking more in depth about how to handle complaints, how to communicate, how to come to agreements. These things are very important. How you handle a complaint initially once it's first received can really impact what happens if this is escalated to an investigation by HUD, because they're going to come back and they're going to say, well, what happened when this complaint was reported? How was it handled? In HUD's eyes, that will shed some light on whether this incident was discrimination or not, but also what your intent was as a housing provider or manager. So I do want to share a few other tips, and we're getting to it's 2:50, and this is going to wrap up, scheduled to wrap up at 3. So we are getting to the end. So I do want to remind you that you have the ability to ask questions using the GoToWebinar control panel, and so I invite you to do that. I will respond to questions once I finish the last couple of slides. So I want to share here, we know the common phrase, an ounce of prevention is worth a pound of cure. And so what we're saying is that if you can do small things that prevent either discriminatory practices or claims and things like that, then it's worth avoiding the process of resolving issues, of going through an investigation process with HUD, and potentially costly or burdensome settlements. So I have 5 bullets here. Have written policies and follow them. It is important that you have screening policies and procedures that are written, that are clear, and that are ironclad. The same goes for eviction policies, how you handle complaints, maintenance policies, so on and so forth. Number 2, training is essential. Ongoing training is essential. Last year, for instance, in, I want to say September or October, HUD released a new rule on harassment, which makes it clear that supervisors and even owners of properties can be held responsible and liable for harassment by employees or residents towards other residents. Again, this harassment rule we'll discuss more in depth in the May webinar, but annual training will ensure that your staff is up to date on the latest rules and regulations. So it's not enough. It's important that when you hire somebody, bring them on staff or whatever is their initial kind of introduction to your organization, that thorough training happens at that point on fair housing and fair housing issues and concerns. But it is also important that there's ongoing training to make sure that they're updated, that their memory is refreshed, because that's one of the things that you want to be able to say, we've done X, Y, and Z to ensure that our staff is trained. And so if there is, by some chance, a violation, your larger organization and your supervisors, managers, and owners are more protected than they would be if there was no training. So, treat everyone fair. Something to remember is that anytime you do something against established policy, you're creating a trail that can show favoritism. And the flip side of that coin, if favoritism is heads, the tails is discrimination. They're one and the same. So any exception to one resident or applicant that's not extended to another can, in fact, open you up to a claim of discrimination. Again, a reasonable accommodation is not a favor, but a favor is doing something differently because it's a nice thing to do for someone. Although it might be nice, if you do it for a man and not a woman, that could be sex discrimination. If you do it for a African American but not a Hispanic, that could be race discrimination or discrimination on national origin. So you have to be very clear about what your policies are and implementing the policies that you have as written across the board. Listen to applicants and residents. When I say listen, what I mean is listen to people's concerns. Don't be quick to deny requests for accommodation or modifications. This does not contradict the last bullet, which was treat everyone the same. But what it is making sure that you have an understanding that sometimes you need to modify policies, and you do that in a transparent way, and you communicate that to everyone so everyone knows why you're doing things. That way, again, you're more protected from fair housing claims of discrimination. This is not only good customer service, and good customer service is good for your bottom line, but it can avoid the headache of a fair housing investigation, and again, another costly settlement. Your records on rental applications, decisions against applicants or in favor of applicants, along with rationale, it's important that you keep those records, that you retain records for some period of time. And the reason for this is if there's a claim of discrimination against your organization in how you approve applicants, for instance, you want to have a trail that shows that you acted over time in a non-discriminatory manner. That doesn't mean that someone might make a decision later that's against that, but what you want to do is show that you have a culture that is of equality and in compliance with the letter and the spirit of the fair housing law, which can mitigate kind of the penalties that you might experience later on. So those are my 3 quick bullets for individuals. And the one I didn't mention is, the one thing I didn't mention is resources. And so in addition to these 6 bullets, I'll also share some resources with you. But again, I just want to remind you, submit your questions if you have any as I wind towards the end of my material. So, the resources that I was talking about, for education purposes, for training purposes, and things of that nature, even though it's not listed here, of course, another shameless plug, the first resource I have to mention is Quadell. We provide certification trainings on fair housing, including one coming up that I mentioned in Philadelphia in early June. We also can design custom trainings for your organization. So regardless of the type of organization that you have, if you're a multifamily building, if you're a public housing agency, if you're a city agency, we can design trainings that are appropriate for the type of business that you're engaged in and also for your location. So a training in Philadelphia is going to have some material that's different from a training in Topeka, Kansas, which is going to be possibly different from a training in Seattle, Washington, depending on the state laws and regulations. Beyond that, the National Fair Housing Alliance is a great source of information and education. HUD's Office of Fair Housing and Equal Opportunity, which is really the gatekeeper for all these fair housing issues, and they also have local offices all across the country, so that they have their website, which you can go to, hud.gov, and then they have a page for FHEO, which you can see with contact information for local officials. Also here I have a link to the Fair Housing Act, to one source of the Fair Housing Act on the website. This will show you the actual text of the law if you're interested in reading it and sharing it. In addition to these that I have listed, there are going to be local fair housing advocacy groups wherever you're located. So a simple Google or Yahoo search, if you prefer that, will help you to determine the education, mediation groups in your area. There's my friend plug again. May 17th is part 2 of this webinar, and you see here the subject matter that we're going to talk about in depth: reasonable accommodations, including assistance animals. Nationwide, in probably every state in the country, but certainly across the country on a federal basis, the #1 type of discrimination claim is for disability. That includes reasonable accommodations, that includes assistance animals, that includes changes in policies and procedures for individuals with disabilities, and reasonable modifications. So we'll talk in depth about those subjects. I want to say in the last couple of years, because I can't pinpoint the exact year off the top of my mind right now, but there was guidance issued by the Department of Justice and HUD on how to treat individuals with criminal records as to avoid disparate impact discrimination. So what that means is, does your criminal record policy disproportionately impact certain protected classes without rationale? So we'll talk more about that. We'll talk about the Violence Against Women Act, which deals with stalking, dating violence, and domestic violence, not only against women but against men as well. We'll talk about the quid pro quo and hostile environment harassment rule that came out last year, that again extends liability to supervisors, managers, and owners potentially. So that's really important that you understand that. Lastly, we'll talk about how to handle complaints, which I did a little bit. I did one slide earlier, but really the nuts and bolts of how to communicate with individuals, how to avoid escalation, how to satisfy both parties. We'll talk about that as well. Be on the lookout for information about our certification course. You'll get an email once the dates are set. It'll be located in beautiful Philadelphia in early June. Also, our website, quadell.com/trainings, will contain all of our training offerings, which you can access at any time. So beyond fair housing, assisted housing manager, HUD, multifamily housing, tax credits, all sorts of things that people in this industry are interested in. All right. We have now reached the end of the webinar. I did have one question, or I received rather one question. I don't know where the questions went, but the question had to do with certifications. So this webinar today and the part 2 webinar, these are not certification courses. This is an overview. Part of the challenge in doing a webinar like this and providing you with certification is you don't walk away with any knowledge for your particular state or area. And I wasn't really able to cater this to whatever industry you're in, because if you work for a housing authority, the information will be slightly different from if you work from a state housing agency, or if you work for a multifamily housing provider, and if you have a building for elderly and disabled versus a building that has a different kind of population. So for certification, you really need to attend either the Philadelphia course or contact us about a custom course for your agency. So that was a really good question. Are there other questions? Okay. Registration for part 2. I have a question. When will that open? That should be open. If it's not open now, I haven't checked, but that should be open soon. When we send out the notification about the June training, I'll make sure that there's a notification about the part 2 registration as well. Very good question there. So we have a question: in a HUD property, can the owner make the resident pay for a modification? That is a really good question. So if you remember earlier, I said that reasonable modifications have to be provided for at the tenant's expense. Now, with HUD properties, because they're in other properties that are funded by the federal government, they're going to have different rules. And so depending on the type of property, and really depending also on the change, the answer is probably going to be a no, but it'll depend on the specifics of the property and the request. More times than not, the property is already going to, I can't imagine in cases where properties aren't just generally accessible. So when we're talking about elevators and doorways and things of that nature. But so the little things in terms of a raised toilet seat or lever hardware, these are most likely going to be borne of the owner of the property, but again, it varies depending on the property. So feel free to email details to me about your specific property if you want to follow up with more details to get a different answer. I had my email is here. That phone number there is for our main office, but feel free to email me that question. I will, the questions, you can keep sending those. Otherwise, if you don't have any more questions or you're not interested in hearing people's questions, you can feel free to exit. Thank you very much for your attention, and I look forward to seeing as many of you as possible in part 2 and hopefully in the June certification course, which I will be teaching myself. Will this be available for download? It will be for individuals who have attended, I believe. So on our page currently there are trainings, past webinars that you can download. I did one personally on mobility counseling a couple of months ago, and you can view that. But yes, you should be able to view this training via a YouTube video at at your convenience. Can managers tell residents their family members can't spend the night with them? Great question. So I'm trying to think of an example where my answer would be wrong. Now, yes, now it will depend on the type of property we're talking about. If we're talking about a kind of the run-of-the-mill multifamily or single-family property, even if it's an elderly property, subsidized, I can't really think of an instance where you could deny someone a guest that can spend the night. Now, we're talking about one night versus, 30 nights. There's a huge difference there. And your property, assuming that there's some kind of a subsidy attached to it, your property should have a policy for residents to tell them, how long a guest can stay before they're not considered a guest anymore. But generally speaking, unless you have a, really specific type of property that's maybe, obviously if it's a homeless shelter or something like that. But if you have people and they have a lease, number one, your lease should detail, your guest policy. But generally speaking, I can't really envision a scenario in which you could deny someone, a resident, the right to have a guest spend the night in their property. Now, the answer can vary by the individual, so on a case-by-case basis. And I'm not talking about the resident, I'm talking about the family member. So if a family member has in the past caused problems at the property, if they've threatened the well-being of staff or residents, or there's another reason why they would be a danger in the property, then yes, that would be perfectly acceptable to say, you have been barred from this property, and you may not come here even though your mother or brother lives here. Again, on a case-by-case basis, and you got to have documentation of these previous instances to really protect yourself from that situation, and you have to communicate clearly with the resident. Question: a father wants his baby's mother to stay with him since she is homeless, but they are not married. What are their rights, if any? And so I'm guessing you're talking about the rights of the resident, the father. Again, if this is the kind of property that allows individuals to move in, you should have a process by which someone can add family members to their lease, and you might restrict that to certain times maybe, or something like that. But if there'll be, it can get tricky if you're talking about, I want someone to move in and I want to, move to a different unit, or I want somebody to move in and, I need a larger unit is what I'm trying to say, versus this is, my significant other and they're going to move in. Then if you have eligibility criteria, then that individual has to meet them regardless of their relationship to the individual. Now if it's if it's a senior facility, again, you can prevent families with children. So if there's a baby involved, you might have criteria that say they can't live there. Again, it would have to meet that criteria that I talked about before, where those discriminatory prohibitions don't apply to familial status. But otherwise, they just need to follow policy. It needs to be above board. If you are doing eligibility and income verifications, they would be subject to all the rules of your program that any other resident is subject to. Okay, moving the same unit of a project-based housing. So I'm going to say yes. If this is project-based housing, then I'm guessing you have an admin plan that you're following, an administrative plan that the housing authority is following for for the units. So if you're operating a multifamily building that has project-based units in the building, those units and the tenants have to adhere to the policies of the housing authority in terms of eligibility, in addition to whatever you have going on in the building in terms of policies. But again, I can't think of a legitimate reason that a building or a housing authority would refuse to allow a significant other to move in. Obviously, again, if this is an incident, if this has to do with occupancy, so if you have only efficiency units and you have the mother and the baby moving in, that could be a safety issue. Or if it's some kind of if the building's some kind of permanent supportive housing, then that could be an issue as well. But generally speaking, again, there are really very few situations in which you can restrict occupancy in that manner. So I will stick around for another minute or so, see if we have other questions roll in. And I do want to say that that last question about the father wanting the mother of the child to be able to move in, even though that might seem like just a run-of-the-mill, occupancy eligibility kind of question, it certainly has fair housing implications. So that was a really good question to ask in this forum, and questions, and that just illustrates how housing policy and fair housing go hand in hand across the board. So there are no areas in your housing, and all your policies are subject to fair housing regulations, from, again, maintenance to occupancy to eligibility to eviction, so on and so forth. So that was a very relevant question. All right, well, thank you all again for your attention, for your questions. I hope you enjoyed this. I hope that you register for the May 17th webinar. Again, it'll be online hopefully today, and if not, definitely tomorrow. You'll also get information in the coming days or weeks about the June certification training in Philadelphia, and I really invite and encourage you to contact us about a customized training for your organization. They really are a lot of fun, very informative. We do case studies, we do hands-on trainings, we do a lot of interaction to really make sure that everyone there, regardless of their role, understands how their actions are, how in their actions they have to consider housing discrimination in the Fair Housing Act, from the architect to the accountant. And so like I said, we have a lot of fun with those. They're very interactive, so I encourage you to do that. Otherwise, have a great day. Again, thank you very much.